Hello, my name is Ben Hart. I'm an American attorney and the Managing Director of Integrity Legal here in Bangkok, Thailand. This video today is going to discuss U.S. immigration in the context of what's called Consular Non-Reviewability, or also it's a doctrine known as Consular Absolutism. What it basically means is that the consular officers, and these are the officers that adjudicate visa applications at U.S. embassies and consulates outside of the United States, basically the doctrine states that these officers' decisions are not subject to review. And what we mean to say here is that these decisions cannot, like, say, be appealed into a U.S. court. But even more deeply than that, it basically is also a doctrine which presupposes and makes a presumption that that consular officer is in the best position to make a determination on the matter, and for that reason, essentially, again, their decision isn't going to be reviewed, and moreover, a great deal of weight is going to be placed on that decision. As anybody that can tell you, if one has been denied for, say, a tourist visa under what's called Section 214B of the Immigration Nationality Act, there's a video on this channel regarding those matters. If you've been denied under that for a tourist visa, subsequently trying to reapply for said visa, you're going to have to prove, the applicant is going to have to prove up a substantial difference in their circumstances compared to the previous application. That is due to the fact that these consular decisions, in these cases denials, are basically given a great deal of weight. And by a great deal of weight, I mean, preponderantly weighty sort of perspective that everybody's going to put on that. So, for that reason, it's very important in cases involving U.S. immigration to present the strongest case in a given situation, and moreover, to provide as much information and evidence as one can. And it's also important to know the sort of posture one is getting into with respect to a visa application. Now, it should be noted that certain other types of denials are less final. For example, the 221G, which is sort of like a deferred decision. It's basically, look, I'm issuing a 221G, bring back more documentation, and if I deem it worthy, we're going to go ahead and issue that visa at a later date. It is technically a refusal, but it's not an outright denial. But more to the point on this matter is, it's sort of, again, there's certain presumptions that folks tend to have, especially American citizens, because they don't have to deal with their own immigration apparatus. It's sort of an irony of immigration law that people who live in the country that the immigration law applies to have very little idea of how it actually works, because they never have to deal with it. If you're a citizen of the United States, you don't particularly have to deal with U.S. immigration. You pass through an airport, and as long as you're not carrying anything illicit or illegal, you pass through U.S. Customs and Border Protection, they see your passport, on you go. But when you're an alien, resident or otherwise, trying to get in the United States, it's a totally different endeavor. I only bring this up, again, to sort of dispel any presumptions people have with respect to quote-unquote rights that one has in, say, a visa embassy, and say a visa interview at a U.S. embassy or U.S. consulate abroad. There are no rights attached. If it's a foreign national on foreign soil, there's very little legal protection, at least constitutionally, that's going to attach to that individual. Department of State has a great deal of discretion in these matters. They can utilize it. And really, their decisions are not appealable. One of the reasons, if you go back sort of in the case law on this, essentially the justices of the Supreme Court and some of the appellate courts that have sort of ruled on this, one of the major issues that they ruled on was, look, we really don't want to jam up the U.S. court system with a bunch of denied visa appeals. And I can understand that. It makes some sense in terms of judicial efficiency. They would have dockets that stretched on for days and days and days on end of just visa appeals if that was a possibility. So for this reason, it should be noted that when interviewing for U.S. immigration matters, that consular officer has a great deal of discretion in the case, and one should not make any presumptions with respect to the posture of the applicant in that case. If it's a foreign national on foreign soil, that is what it is. There's not a great deal of legal protection that's going to be sort of given to that foreign national at the time of the application.